And now, I have the great pleasure to give the floor to our first speaker, Alain Werner. Alain, you have the floor.
Thank you very much. I apologize, as always, for my very deep and thick French accent, which has never disappeared over the year. So deepest apology for those of you who speak proper English to have to listen to my broken one. So the idea for me, I will try to do that in 10-15 minutes. The idea for me is to give you a flavor of what people like myself or others who are lawyers in the field of international criminal law could do if a victim of sexual slavery wants to find criminal justice today in the world of international law. And I will focus on a scenario where a victim would be from Iraq or Syria, but obviously, and I will try to distinguish as well, it will be the same reasoning for a victim of Nigeria or anywhere else in the world. So I guess the first for us, the first question when you have someone who wants justice, obviously, it's always to find justice in the country where the crimes happened, wherever they happened. And we all understand that sometimes, often, it is not possible for those victims to find justice in those countries for the reason that the perpetrator of those crimes may be in power, or the judicial system is not equipped to adequately protect them, protect their testimony, or to give them the certainty, or at least the prospect of a fair trial. So most of the time, we international lawyers, we intervene in situations where it's not possible, for example, for victims of sexual slavery to find justice in the country where the crimes happened. And this is where you start reasoning and asking yourself, okay, let's say a Nigerian victim cannot find victims in Nigeria, or an Iraqi or Syrian woman cannot find victim justice in Syria or in Iraq. Because if they can, then obviously the best option is to try to take the best lawyer possible and to try to seek justice where the crimes happen, because presumably the judges there should understand the context, and in an ideal scenario, ideal world, this is where one should find justice. Now, if it's not possible, then of course the first option one would think of, and I guess everybody knows now for 20 years this is the institution, and this is the International Criminal Court in The Hague. The International Criminal Court started to function in July 2002. There will be celebration this year. It will be the 20th anniversary of this very important court. Now, this court is complicated in a way because you can find justice in front, possibly or hopefully in front of the International Criminal Court first if the crime happened after July 2002. Otherwise, it's outside the scope of the jurisdiction. And then you need to have jurisdiction, okay? And the jurisdiction is set up or triggered by a mechanism which is a bit complex. But to simplify things, let's say that for a Nigerian woman in Nigeria, Nigeria ratified the International Criminal Court in January 2001. So any crime in Nigeria could be potentially in the jurisdiction of the International Criminal Court. But Iraq and Syria did not ratify the International Criminal Court. So for victims from Syria or from Iraq, they normally could not have jurisdiction if there is no other ground of jurisdiction. They could not have jurisdiction in front of the International Criminal Court. The International Criminal Court, when it started, there was a lot of hope for the victim, because if there is jurisdiction, again, for example, for Nigeria, there is a system in the International Criminal Court where victim representation is possible. So this is different from, for example, what we call common law country, from like the United States, the United Kingdom, or many other countries, where there is no representation of victims by independent lawyer. This is a system that we do know normally in continental Europe, for example, in Switzerland, in France, or in other countries. And international criminal court, you do have this option, which make it interesting. Now, let's be clear about the International Criminal Court. I said that we will celebrate this year the 20th anniversary. The assessment so far is complicated in a sense that the Office of the Prosecutor has been able to secure only 5 convictions for a budget of over 130 million euros a year. So you can understand that several billion of US dollars have been spent for a result, obviously, which was not what was expected on the side of the victims 20 years ago. So nobody should think that there is a easy and clear path to justice for the International Criminal Court. And obviously we can talk more in details, but this is sort of the first big question one has to ask himself or herself, looking for justice for the crimes of sexual slavery, because of course, within the statute of the International Criminal Court, sexual slavery and enslavement is both a crimes against humanity, Article 7, alinéa 1, literal C and G, and as well war crimes, Article 8.2e, capital 6. So it's both qualified as a war crime and as a crimes against humanity. But again, there are many, many conditions for jurisdiction. And even if you have jurisdiction, the prosecutor can decide or not to take a case. It can be referred by a state, but all of that is quite complicated. So it's not a straightforward path, as it is indicated by the very low number of conviction after 20 years in the ICC. Now, outside this International Criminal Court, you have other international mechanisms. Before the ICC, you had a number of them which were set up for particular situations, like former Yugoslavia, or Rwanda, or Cambodia, or Sierra Leone. And those were international courts exclusively set up for a geographical situation, and normally for a number of years. And then you have other mechanisms, and these are really of interest for us when we talk about Syria and when we talk about Iraq. And I'm not aware of any such mechanism for Nigeria. And these are mechanisms which were set up by the United Nations because the political situation was such that we knew that there could be no justice in front of the International Criminal Court, or in fact in front of any other international tribunal. And take Syria to start with. So Syria, as I said, has not ratified the International Criminal Court, so there could be no path to the ICC that way. There could be another path for the ICC, would be the UN Security Council, which refer the situation to the ICC. For example, Libya was one of those examples. But of course, it was tried on Syria in early after the war, and there was a veto by Russia and by China. So it was not an option. So definitely the path to the ICC was blocked. So what did international community did, which was, we think, a step forward, and this is to create a mechanism which is located in Geneva, Switzerland, and this was created by a resolution in December 2016, and this mechanism is now called in our world, called the IIIM. It has a very, very, very long name, the International Impartial Independent Mechanism to assist in the investigation and prosecution of persons responsible for the most serious crimes under international law committed in the Syrian Arab Republic since March 2011. The idea here was that as you could not get an international court, then at least, and you could not for now get the ICC jurisdiction, let's investigate, let's have a body from the UN, which is in a way the first step of the rocket of justice, which is investigation. So let's secure, let's preserve the evidence as much as possible, and then let's have this UN mechanism which could collaborate with other national or international mechanisms and function in a way as a very big repository, very big place where all the evidence is secure, all the videos, all the statements, all any other exhibits. So this was the idea of this mechanism, which started functioning in 2017. So it has been 5 years now. It is said, and I'm not working for them, but it is said that they have already collaborated, and I will come back to that, with national authorities for investigation on Syria. So this could be a way for any victim of sexual slavery. Of course, their mandate includes and encompasses the crime of sexual violence, sexual slavery, enslavement. So any victim could get in touch easily online with investigators of that tribunal and talk to them. Now, of course, it's not a tribunal. It's an investigative body. And this is for now the situation. And they would collaborate with, again, court, international, national, but they are not themselves a court. And there is another mechanism, a bit similar, for Iraq. This one was created differently. This one came directly from the UN Security Council. And one could wonder if the Security Council, without a veto from China or Russia, created that mechanism, why they didn't refer this Iraqi situation to the ICC. But basically, the Security Council created in December in 2017, a mechanism which is called the United Nations Investigative Team to promote accountability for crimes committed by Daesh, ISIS. We call it UNITAD. It is called UNITAD. UNITAD is different. It is not based in Geneva. It is based in Iraq. And the mandate of UNITAD, again, is to preserve the evidence, but UNITAD as well has a direct mandate to collaborate with Iraqi courts for justice. The problem here that we have is that the mandate, of course, it's within the United Nations, and as we all know, the United Nations does not condone by any way the death penalty. And as we know, the Iraqi courts very frequently they with death penalty in Iraqi courts today and every day requested against alleged or perpetrator of Daesh. And this is a big problem because this prevents UNITAD to collaborate on cases with the Iraqi court, again, because there is the death penalty. So this is another possibility. This time there is a more direct link to the court, which are the Iraqi courts, but again with one problem, which is the problem of the death penalty. To go quicker now, so this, if you want, are the biggest mechanism existing today, which are either international court like the ICC or mechanism which were created by the United Nations. And then you have a very large number of other possibilities that I'm just going to go through here without giving you any detail because I don't have the time, but which are basically many mechanisms under the UN system where something could be done. But again, let's be clear, it's not a court and it's not going to bring any trial in court. The first one, of course, is the Commission of Inquiry on Syria. So this was the body set up in 2011. We know it well in Switzerland because probably the most famous person, a Swiss person under international criminal law, Carla Del Ponte, who was a prosecutor for the tribunal of Rwanda and former Yugoslavia, was a commissioner, as other. This one now still is existing, still collaborates. Of course, as you understand, there is now a triple IM, so there is several different mechanisms. And then you have all what we call the other proceedings, other mechanism of the UN, which are the special rapporteurs, who are UN appointed employees, whose office, most of them are based in Geneva, and who are persons who can make communication, can make recommendation, but again, they are not prosecutors. They do not have jurisdiction over any tribunal. You have a special rapporteur on contemporary form of slavery. You have a special rapporteur on trafficking in person. You have a special rapporteur on torture. You have a special rapporteur on violence against women, on discrimination against women. So you have all these mechanisms which as well could be seized. Let me finish by saying this. All of that, again, will not most likely, at least for Iraq and Syria, today, will not itself bring you any case in court. There is a final, and this is my final remark, and this is what basically we are doing with Civitas Maxima, not on, for now, on Iraq and Syria, but on Africa. But there is something else outside this UN mechanism, outside this international court, and this is what we call universal jurisdiction. And this is basically simply the fact that national courts, so courts of any country around the world, may have jurisdiction even if it's not the country where the crimes happened. And let's take, for example, again, the situation on Iraq and Syria. I don't know on universal jurisdiction very well the situation on Nigeria, but on Iraq and Syria, you have a number of courts, especially in Germany, which took cases. So here you have German prosecutors who had jurisdiction for crimes, international crimes, so torture, war crimes, crimes against humanity, committed outside Germany, committed in Iraq, or committed in Syria. And this is quite extraordinary. And this works like this. Let me give you 3 simple examples to show you how that works. Last year in Hamburg, in Germany, you had a woman who was both from Tunisia and from Germany. She was part of ISIS, and she was convicted by a German court for sexual slavery against 2 Yazidi women for acts which were committed in Syria. The jurisdiction was given because that woman was German. Okay? She was German, she was Tunisian as well. She committed crimes outside Germany. In Syria, she could be tried for war crimes in Germany. So this is the first example. And you have 2 other examples. Another woman, this time in Munich in October, called Jennifer Wenisch, a German citizen again, was convicted again for crimes committed in Syria, where a 5-year-old child was chained, abused, let under the sun, so long that that child died. Okay? That woman, again, because she was a German citizen, even if she committed crime outside Germany, against no German citizens were victims, they were victims in Iraq and in Syria, she was convicted. And the third example, which is very interesting, is a husband. The husband of Jennifer Wenisch, this time it was a man called Tahal al-Jumali, all of that is public, and he was sentenced to life for genocide, crimes against humanity, and war crimes, again, for having bought and abused sexual slave and for the murder of that woman. Now, what is interesting here is that Tahal al-Jumali was not German. The 2 others were German, and the jurisdiction was given by the nationality. But here you have a gentleman who is not German, is Iraqi. Okay? The reason why he could be tried in Germany is because at some point his physical presence, he was in Germany. And his presence in German soil gave jurisdiction. In other words, he was not German, he did nothing against German, he did nothing in Germany, but he was himself present in Germany, committed crimes elsewhere, international crimes, and as a result, he could be tried. If he had murdered in peacetime his neighbor in Iraq because the neighbor was sleeping with his wife, he could not have been tried in Germany because it was not an international crime. But he was tried for sexual slavery and other crimes, and these are international crimes. And because they are international crimes, they give you the jurisdiction even if it's not tried in the country where it happened. So this is, in a nutshell, the landscape today of international criminal law when it comes to sexual slavery and enslavement. This gives you a picture, and I will finish by these words. This gives you a picture which is not perfect by any means. And when you look at the number of convictions, it's completely, obviously, unsatisfactory for anyone. But let's say that there was nothing which can be done on behalf of the victims. If you have enough links with jurisdiction to, in my view, at least in a certain number of scenarios and cases, try to bring justice to these victims. Thank you very much.
Thank you very much, Alain, for this excellent introduction on the value and limits of the ICC, International Criminal Court, on its 20th anniversary. And thank you also for mentioning all those other special mechanisms, including also and reminding us of the principle of universal jurisdiction, which, of course, should be used more often, and especially in cases of human trafficking.